Hey everybody, how's it going? Welcome back to Copper Jacket TV. Today I have a really important update in Miller v. Bonta, which is California's assault weapons ban case. It's currently sitting in front of Judge Roger T. Benitez, also known as Saint Benitez, for reconsideration, and there is a meeting tomorrow morning on this case. So we could see some movement, but there are also some pretty big snags, and I want to talk to you guys about those. So let's go ahead and get to it. Now, real quick before we get started, most of the people that watch these videos are not subscribed. So if you wouldn't mind, just take a quick second, hit that subscribe button. It's free. It helps me out quite a bit. And if you wouldn't mind, check out the main sponsor of this channel, which is the USCCA. They're linked down below. USCCA offers self-defense liability insurance, online education, training. You get a magazine, and so much more. So it's definitely worth it. It's probably the best membership you could ever have in your wallet. So let's get to the video. Now, just in case you haven't been keeping up with Miller v. Bonta, let me give you a quick update as to what's going on here. So this was originally heard by Judge Benitez. Benitez found that it was unconstitutional for California to ban these weapons. Then it went up to the three-judge panel of the Ninth Circuit, who found the same. It was a 2-3 vote. They found that it was unconstitutional. After that, it went up to a full panel of the Ninth Circuit, who found that California, because of their interest, they used the interest balancing approach, California had enough interest to basically ban these, and they found that it was constitutional. It then went up to the Supreme Court, and after the decision in Bruin, the Supreme Court decided that they were going to vacate the decision of the Ninth Circuit in Miller and then remand it back down to the courts and basically tell the Ninth Circuit, do it over again in light of Bruin. We want you to use text, history, and tradition, not the two-step, not the balancing approach. We want you to look at the history of the Second Amendment and what's in the text and come up with a new decision, right? Well, the Ninth Circuit decided that they're going to take it now and send it back down to the original person who had it, Judge Benitez, for him to make a decision. Now, the decision by the Ninth Circuit to send this back down to Benitez is pretty much nothing more than a stall tactic. They already know what his position is and where he stands. He originally used text, history, and tradition when he came up with his decision that it was unconstitutional. So we already know where he stands on this, and we know where he's going to stand again, because basically it went back down to him because of Bruin, which says that you have to use those exact same things, text, history, and tradition. He already did that. So we know that he's going to find it unconstitutional again. I have no doubt in my mind whatsoever that he is going to find it unconstitutional. But he has to go through procedural steps, and tomorrow is one of those procedural steps. Now, here is where the wrinkle kind of comes in, okay? Gavin Newsom signed into law a bill that kind of intimidates people now from filing lawsuits for their civil rights, okay? So what the law says that Newsom signed is that anybody who files a lawsuit, let's say, over your Second Amendment rights, so you have a mag ban, you have all sorts of bans in California, right? You decide to file a lawsuit against one of those. If you actually file a lawsuit and it goes through the court system, let's say it takes 3 years, right? And then the case gets dismissed, or California wins, or, something to that effect happens, the party that filed the case has to pay California for all of their legal fees, attorney fees, and everything else. So you're talking about cases that typically take years. I mean, sometimes 5, 6 years, 10 years to get an actual decision in. That is a lot of time racking up money. And so now every single attorney out there, every possible plaintiff out there knows that if they bring a suit in California, there is a potential that they would have to pay California back for that 5, 10 years worth of work, which is more than likely going to be millions of dollars and potentially bankrupt anybody involved in that case. So again, it basically makes everybody look at these things and go, well, I know I have a case here, but I'm not sure if I want to, go through with that because the courts tend to lean left, and what if I lose? I'm basically going to be bankrupt for the rest of my life, and California is going to come after me for all this money. So to me, that's intimidation. They're saying, look, don't even try it. If you do try it, we're going to go ahead and take everything that you have. Now, obviously, that has some bearing on this case. This is another case that's been going on for a long time. So now you have these plaintiffs, and now you have the attorneys on behalf of the plaintiff who are looking at this saying, uh-oh, if something does happen for some reason, and the Ninth Circuit just decides to defy the Supreme Court altogether, we could be on the hook for years of fees from California. And so the plaintiffs in this case, and those representing the plaintiffs and those in support of the plaintiffs, including the FPC, the GOA, San Diego gun owners, a bunch, basically the Second Amendment Foundation. There's a whole list of people who attached to this letter to Benitez saying, hey, look, in light of this new law that Newsom signed, we need to have a meeting. We need to talk about this and figure out exactly whether or not this is going to apply, whether it's going to hold water, whether or not, this is something that, is eventually going to be overturned, and kind of go from there. And so that was a letter that was written prior to this meeting tomorrow. And so I'm thinking that a majority of this meeting that they're going to have in the morning is going to be talking about that new law that Newsom signed. Again, in my mind, something that tries to prevent people from filing these lawsuits. But I think they're going to be talking about that mostly. Now, this could help Benitez kind of speed things up and hurry things through and, put an injunction on this until, everything gets sorted out. So we could see some movement in a positive manner even faster than before. This might move things along even quicker, but at the same time, it puts a big wrinkle in there, because if California decides to delay this, then, there could be some trouble if it doesn't go our way. So again, big meeting tomorrow. They're going to be talking about a lot of stuff, I'm sure. This letter and the new law are going to be probably at the forefront of that. But at the same time, Benitez already made his decision. He already knows what he, why he based his decision on Texan history before. He's going to do the same thing again. And so there is a fair likelihood, I think, that he's just going to say that it's unconstitutional and put an injunction on it. That's what I think is going to happen. I'm not, a legal scholar by any means, but just watching his actions in the past and how he handles these things, I think shortly you're probably going to see him say that it's unconstitutional and put an injunction. California's going to ask for an emergency stay, and then we'll go from there. But we'll see what happens. But at least we have some movement in Miller v. Bonta and try and get rid of these ridiculous anti-2A laws in California. I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.